starters, we handle 5,000 cases a year, so the vast majority of our cases we have to reach some sort of plea bargain. We cannot take 5,000 cases a year to trial. Here in Park County, you deal with approximately somewhere between 125 and 150 felony cases a year. You cannot take 3 felony cases to trial every single week in order to try all of the felonies that take place in Park County. So you have to reach plea bargains in the vast majority of your cases. It's simple math and it's simple a concept of resources that you have available to you. So how do you decide which cases you're going to reach a plea bargain in? You look at the case and whether or not you have, you look at what kind of sentence you would get from your judge in that particular case if you were to go to trial. If that sentence is significantly greater than the sentence that the defendant is willing to accept in a plea bargain, then that's a good case to take to trial, because you will get a more appropriate sentence from your judge than you will get from a plea agreement. If you're looking at a case where the judge would give probation in the case, even if you went to trial, then that's an appropriate case to offer probation, and if the defendant's willing to accept a probationary plea agreement, then that's a good case to reach a plea agreement in. So you look at cases where the judge will give a sentence that's more appropriate than the defendant is willing to accept in a plea agreement, and then of course you also look at your high-profile cases, your homicide cases and your high-profile sex assault cases.
Both as a prosecutor, a former prosecutor for one of the largest offices in Colorado, and also as defense counsel. So I come from both sides of the aisle. As a prosecutor, when I look at a plea agreement, I consider first and foremost the defendant's criminal history. That's the first thing I look at. Is this a first-time offender, or is this somebody who has been in the system repeatedly? Is this somebody who has been in the system repeatedly and failed to complete prior probation sentences? If that is it, and he or she is currently charged with a violent crime, that alarms me even more. I would ratchet and tailor any type of offer to this person to keep the community safe and to hold that offender accountable. Especially if I know that the judge is a light sentencer, what I would do, and as a prosecutor, you do have the tools to add habitual counts and to add sentence enhancers to get the result that you need to keep the community safe from the judge. So those are my number 2 criteria. What is the type of crime? Is it violent? Is the community safety at risk? And then 2, what is the offender's history?
What's interesting about this issue, as you can tell from both of our answers, quite frankly, is that the strength of a plea agreement depends far more on the judge than it does the district attorney. So what's been interesting about this campaign process is the district attorney is highly criticized for various plea agreements, when the truth of the matter is it depends far more on the philosophical stance of the judge. The other key factor that my opponent skips over in reaching a plea agreement is the strength of the case. Can you prove the case unanimously to a jury beyond a reasonable doubt? If the answer is no, or you may have some significant problems with that, you need to look to reach some sort of plea agreement in that type of case.
What current procedures or processes would you want to change for efficiency or to promote more expeditious processing?
Well, I'm taking off where my opponent left off in terms of your case strength and evidence strength. This is my top priority, to restore this relationship between law enforcement and the DA's office. Problem is we're a large district geographically. We have 4 counties: Park County, Chaffee County, Fremont, and Custer County. And in this budget crisis and at the time of limited resources, it is of uttermost importance to revive and keep strong that relationship between law enforcement agencies and the DA, because the DA, the elected DA especially, sets the tone. He is a chief law enforcement officer, and it will behoove both branches, the DA and law enforcement, to use resources wisely. So I would invest considerable amounts of time in training with law enforcement, and also law enforcement to take deputy prosecutors for ride-alongs, so we could get both perspectives. How can we investigate cases from the beginning on to make them stronger later and more provable at trial? And I think we will protect the community better through that kind of
I suppose I admire that's a bold initiative of my opponent to be all things as district attorney, law enforcement officer, investigative training to the law enforcement officers, as well as prosecutor. The truth is, we already have a law enforcement agency. You've already elected a sheriff in Park County whose job it is to properly investigate the cases and present those cases to the district attorney's office. It's not the district investigator's office, it's the district attorney's office. Our core competency is going into court and trying cases, not investigating cases. Yes, we work with the sheriff's office, but it's their responsibility to investigate the case properly and thoroughly, not the district attorney's responsibility. And so you already have that agency. We have programs in our office to increase efficiency. Domestic violence fast track case where we bring the case in, we try to reach an agreement as quickly as possible in that case to avoid that case coming back time and time again. We are in the process of expanding our fast track program to include DUI cases. So that's an example of a way in which we've increased our efficiency since I took office.
I guess we could cut, 3 investigators in the office of the DA right now and save on the budget because the DA apparently has no investigative function under this particular administration. In other 21 districts here in Colorado, there's something that is called that you can go directly to the DA for filing of cases, which the DA then investigates through their investigative branch. But that's in the 21 other districts in Colorado, and I think I would like to reinstate this in this district as well, that you can direct file through the DA and launch an investigation. I think it's absolutely crucial to work with law enforcement, and I stand with that particular platform.
You know, my assistant district attorney, a longtime prosecutor, says something interesting. And you hear defense attorneys often say, I love being a defense attorney because I get to protect the community against the man, this ephemeral, the man. And my assistant district attorney always says, you know, the best way to protect the community from the man is to be the man, to be that government and to protect your community directly, not indirectly, to be that person that does the right thing for the community. And that includes not pursuing cases when it's appropriate to not pursue those cases and pursuing cases when it's appropriate to pursue cases.
Okay, Dagna. How much weight would you put on circumstantial evidence when deciding whether to prosecute?
Gee, I thought you were asking me how much weight I gained during this meeting. Eating at all those gas stations. Well, circumstantial evidence. Again, if you as a prosecutor, in terms of filing the case and proceeding with the case, you would look at the totality. You would look at the totality of the strength of your evidence in terms of will you be able to prove it to a jury of 6 or a jury of 12 in terms of a felony case. My preference, again, is circumstantial evidence. What's the definition of that? Usually that's an inference. If somebody picks up a glass of water, the inference would be, well, they're thirsty. Well, but maybe they just want to clear their throat. It's a little bit different than thirsty, but they're still doing the same action. So again, circumstantial evidence to me leaves a lot of room for interpretation. And so again, I come back to working with law enforcement and the investigative branch to make sure that we're on the same page, that they understand that if we only have circumstantial evidence, that's difficult to prove convincingly to a jury to convict in such a case because you have sparse proof. So again, what can we do to improve our investigative branches in terms of interviewing witnesses, collecting evidence, so we have substantial direct evidence proving the case?
I think a lot of people don't realize until they're called upon to serve in a jury that under the state of the law in Colorado, there is no legal difference between circumstantial and direct evidence. In other words, when you go to a jury, the judge will give you a jury instruction that instructs you that you're to consider both circumstantial evidence and direct evidence in the same manner. Now, some types of direct evidence you don't give much weight to, and some types of direct evidence you get a lot of weight to, and it's the same for circumstantial evidence. We have built, and you can build, entire cases on circumstantial evidence. You can try a homicide case without actually having a dead body. by using circumstantial evidence to prove that that individual is in fact dead. So it doesn't really matter if it's circumstantial evidence or direct evidence. What matters is, do you have enough evidence, and does that evidence carry enough weight to be able to prove the case beyond a reasonable doubt? And that's where the real hard decisions come as a district attorney. If you can't prove that case beyond a reasonable doubt, then you're ethically bound to not go forward with that case.
Well, this is where I can't also stress enough the importance of trials. Because if I have a case where it is a close call, but not unethical for me to proceed on this case, because I do believe that there is a reasonable likelihood of conviction at a trial, this is something that I would want the community, a jury of 6 or 12, to decide. I think there's a constitutional right to a jury trial. And when I have a close case where you have circumstantial and direct evidence, I would bring that case to the jury and have the community involved in this decision process.
Okay, Tom. What are the 3 most important things a DA should know, and what are the top 3 skills needed?
Well, I think that it's important that you know your community, for starters. Obviously, it's important that you know the law, but quite frankly, all of that's written down, so you don't have to know it. You just have to know how to work it out. So it's important that you know your community and that you understand the law. For example, I'm dealing with a case where we're analyzing whether or not an individual who was shot and killed, whether or not we should prosecute it, or whether or not it was a make-my-day situation. As you know, under Colorado law, the make-my-day provision allows you to shoot someone if they come into your house. A family member of the deceased individual is adamant that we should be filing charges in this case, and he was pointing out to me Supreme Court cases that have done a lot of real hair splitting. As it may shock you to find that our somewhat left-leaning Supreme Court hasn't broadly interpreted the make-my-day provisions. And he was telling me how the Supreme Court has narrowly defined the make-my-day provisions. Well, I can tell him that a jury in the 11th Judicial District doesn't care about the Supreme Court's hair splitting on the make-my-day provision. I can tell him that a jury in this community, how they will look at that evidence, because I'm a member of this community. I grew up with these jurors. I grew up with them and around them. And I can tell him that a jury in this community will not convict this individual because I would not convict this individual, and because all of you would not convict this individual. All of you would have shot this person if you woke up and he was there, the same way I would. So not only do you have to know the law, but you have to know your community. And the only way to truly know the community is to have grown up and lived in the community.
Well, and while I admire my opponent for his clairvoyant abilities that he's able to predict jury skills, splitting hair, apparently, I am of the opinion, the philosophy, that again, close cases like this, I would bring to the jury. Because in my history as a trial attorney, both as defense counsel and prosecutor, I have been surprised by jury decisions. And later, when I had the chance to go back and talk to the juries, I learned, again, what was a factor or determinative event that turned the decision. So, again, I believe the Constitution is written for a reason, giving the accused a right to go to trial. And so I hammer on this, that this is my number one platform issue. How do you measure a good architect? By the amount of great buildings they have built. How do you measure a great painter? By the amount of paintings and the quality of his or her work. Well, the prosecutor's office is a trial office. Currently, there's 2 cases that go to trial per prosecutor per year, and I will double, if not